Good evening. Happy Saturday, round two. Now we're going to look at some stupid and futile actions taken by Chillie de Castro. This is the Pacer report for de Castro versus Abrams and Peter. And you'll notice that Abrams and Peter were served on the 16th and the 15th of September, respectively. And their answers were due on the 7th and the 6th, again, respectively. Now, on the 3rd of October, there was a letter request for extension of time to file a responsive pleading by Kate Peter. On the 3rd, after receiving that, the judge construed it to be a motion for extension of time to respond to the complaint and granted it. Done. 30 days. Enjoy. 2 days later, there was a letter request for extension of time to file a responsive pleading from Josh Abrams. Again, boom. There you go. You're asking for an extension of time. Here's 29 days. Now they're both due on November 7th. So, yay, right? No problem. And then the day after, there's an application to the clerk for entry of default by de Castro. Weird. It was modified on 10/7/22 to correct filing event used and docket text. So the clerk had to fix it for him. But anyway, it got done. It got done, right? And that's weird. So let's stop here and take a look at what we've been talking about. First, there's the Peters letter. Simple letter. As defendant in the above referenced action, I'm working toward retaining counsel, but I may not be able to do so before the expiration of the time allowed for filing responsive pleading. Accordingly, I ask the court to enlarge the time within which the pleading must be filed. Simple, easy. There you go. Bada boom, bada bing. Serve Chillie. Perfect. Send it to the clerk. Awesome blossom. Well, their addresses are on there, unfortunately, but I'm sure they knew everything was going to be public record at this point anyway. So Josh's letter, same dealio. As defendant in the above referenced action, I'm working toward retaining counsel. It does not look like Josh sent one to Chillie, which is bad form, sir. Bad form. You should always make sure that you send copies of everything to Chillie. But he says, as a defendant in the above referenced action, I'm working toward retaining counsel, but he may not be able to do so before the expiration of time allowed for filing responsive pleading. Accordingly, I ask the court to enlarge the time within which the pleading must be filed. I respectfully request an extension from this court. So they're very, very similar letters, and they got the same results. They got their extensions. Congratulations. Now, the way defaults work is if the defendant has not answered the complaint within the time allowed by law, then the plaintiff can file a request for default, and the clerk will enter the default, and then you can get a default judgment. Now, getting a default judgment, there's sometimes you can get it through the clerk. It depends. If it's just like an accounting thing, then you can get it through the clerk. If you have to actually prove damages, like if there's pain and suffering or something like that, then it's going to have to go through the court. Yes, I'm oversimplifying. Deal with it. But it could go either way is really the point of that. So there's a difference between getting the default and getting the default judgment. The default is basically a recognition by the court that the defendant has not responded. And so now you can start seeking a default judgment. Now, the courts really want all of these cases to be heard on their merits. The court is not going to just say, okay, technically you didn't file on time, so boom, you lose your right to have your case heard on the merits. And that is reflected in Rule 55. Rule 55 of the Federal Rules of Civil Procedure deals with getting a default judgment, and it also deals with setting aside a default or a default judgment. The court may set aside an entry of default for good cause. and it may set aside a final default judgment under Rule 60B. We're not dealing with a final default judgment. We're just dealing with a potential entry of default if Chillie had gotten his way, and the court would have set it aside for good cause. Now, what's good cause? Being late because you got a lawyer and it took you longer to get a lawyer than you thought it would, that's a court's going to say that's good cause. Because again, there is a policy preference for having cases heard on their merits and not having people just get default judgments willy-nilly. So we've looked at those, and then here's his application to the clerk for the entry of default. So he's saying that I served it, and she didn't respond in time, and so he thought it had expired. But unfortunately for Chillie, she had an extra 30 days, and so she's not in default. So his request for default is there is no default entered. Default has not been entered. So it was worthless. So then, after he files his application for default, he then files an opposition to defendant's motion for time to answer. He files an opposition to a motion that's already been granted. That's futile. If the motion has already been granted, the motion has already been granted. Opposing it at that point is just pissing into the wind. You're wasting your time, you're wasting the court's time, you're wasting the clerk's time, you're wasting everybody's time. You're not going to change anything. You're literally pissing into the wind. Not literally, but you're figuratively pissing into the wind. And he filed not one, but two. He filed it twice. And I think he filed it twice because this one he was handwritten. You could see that this page is different. So it looks like they attached this page to it with his handwritten signature. Also has IamAlaskan@gmail.com, which is the email address they have in Pacer form. IamAlaskan@gmail.com. For everybody who's like, "Oh, pro per's fine," I'm just pointing out. I'm not saying, I've never said that pro per means you're gonna get your case kicked out of federal court. I've just said federal courts refer to petitioners or defendants who are not represented by counsel as pro se. That's the way federal courts do it. So that's what I always see. Anyway, so that was the first one, and then he I guess figured out how to do electronic filing because this is an electronic filing signature, and he now has Chillie at situationcreator.com. Situationcreator.com. That's an interesting one yet. I, Jose De Castro, hereby certify that this was mailed to the clerk and all parties on October 3rd of 2022. Well, that's sure. He certified it. There is no certificate. There's no proof of service on this one. Anyway, now there's a certificate of service. So yeah, there you go. Not sure why it hasn't been filed yet. What a douche. Anyway, so the court files them when they receive them. So I mailed it on the 3rd. Well, the court didn't get it till the 7th. So what are you going to do? And if the court can't rule on it till the court gets it. Anyway, that's where we're at. Oh yeah, and then he filed a motion for entry of default judgment. A motion for entry of default judgment. Now that is document 13. That is this one. Another application for default judgment. This one is for Josh. He put down as a motion. He entered it as a motion. Anyway, that's kind of dumb. It's not a motion. It's not a motion. It's an application for default. Anyway, Chillie's floundering a little bit. I'm not trying to give Chillie any hints, but these are the federal rules of civil procedure. A lot of your answers are going to be found in the federal rules of civil procedure. A lot of them, not all of them, but a lot of them. And these might help you out a little bit. Anyway, yeah. So his motions or his oppositions are useless. They're garbage. They're wasted. Kate and Josh have till November 7th apparently to file answers. I I have never seen discovery served on a defendant like before they have an attorney. Um, and well, no, I can't. I'm not going to give any more. I'm not going to give any more information. Anyway, Chillie, a lot of the answers that you're looking at, a lot of the things that you're looking for are going to be in here. Um, so you probably should read Title Five. That's the best I'm going to give you. I know it took you, what was it, 12 hours to get through Tesh Lines versus Danforth, and to finally figure out that all you really have to do is say Virgil's name in court and people quake, and it's not really the case that's important. It was the justice who wrote it, or whatever weird thing you came up with. I don't really remember right now. But you might want to try to read the Federal Rules of Civil Procedure, specifically Title V, Disclosures and Discovery, and that might help you out a bit. Thanks for watching. Have a great day.